Hello, and welcome to this conversation we're having tonight about the Supreme Court's ruling that just came down this morning related to LGBTQ rights and protections for workers across the country. And it's an exciting day. It's a welcome respite in the midst of a lot of turmoil that we have going on in our lives. But I want to just make note that I don't know about you, but I feel like I'm having some whiplash. I mean, the reality is that we got on Friday, we had this um, we had this ruling come down from Trump, legalizing discrimination against trans folks when they're accessing health care. And then for this morning, to get the word, the Supreme Court has now ruled that LGBTQ workers are protected from discrimination under Title VII. It's a lot here to take in, and this, of course, is all in the midst of this COVID-19 health crisis. It's also in the midst of this vitally important nationwide demonstrations and protest in support of Black lives and against the systemic racism in our country. Um, you know, but in the midst of all that, today's decision was heartening and encouraging. And so I'm grateful to have the opportunity tonight to welcome a couple guests here. I am not a legal expert. So it's important for me to bring people in who are legal experts. And so this evening, we have joining us Susan Dunn from the ACLU of South Carolina, and we have Nekki Shutt from a lawyer from Columbia, South Carolina, and an activist in her own right, has been involved in some really pivotal cases here in South Carolina related to LGBTQ rights, but also is an expert when it comes to labor and employment law. And so we're lucky to be able to have both of them here. I'm going to bring them both on screen. Let's see if the technology works. Hello, I can see you all. You look fantastic.
Hello. Hey, Chase. Great to see you. Hey, Susan.
Hey, everybody.
I will tell you now, we already have a lot of love in the comments for you. We got Linda Kettner here saying, "Yay, Susan, Nekki, Jeffrey
Linda.
Fleming, Shelly Quenga, everyone." Everyone's just commenting now, so I'm gonna have to go down all of them individually. But let's just say people love you both, and they're so glad that we can have both of you here tonight. So thank you for being here.
Our pleasure.
Well, with that, I want you all, I gave a very, very short introduction to both of you. And so I want to give you both an opportunity to say a little bit more about yourself, your, the work that you were doing, the work that you have done, and sort of how it, is related to what we're going to be talking about here tonight. I'm going to hand it over. Susan, you want to go first?
Sure, I will. I'm the legal director for the ACLU and have been in that job for a little over 10 years. But I've been an officious intermeddler in South Carolina since the late 70s. So I've seen a lot come and go. And to paraphrase the phrase that was used in South Carolina, this is a great day in America.
Absolutely.
And it was really heartening to read an opinion that didn't stretch the law at all, but really just basically said this is the law. This is not really a constitutional decision, it's a statutory interpretation. And they're really basic premises of statutory interpretation that this case followed. So the rule of law actually worked in this case. The arguments on behalf of the employers was a sort of a strange twist on originalist interpretation of the Constitution. And they tried to sort of say that what was in the minds of the legislatures in 1964 has to be what this law means. When the court says, no, the law is the law, not some kind of contorted interpretation of intentionality. So and they said if they had wanted to define sex narrowly, they could have. And that this statute was very specifically set up to provide relief for individuals who were discriminated against because of sex. And they said there's just no way you can analyze any of the situations that were before the court as if you took sex out of it, these people would still have their jobs. And the employers really acknowledged that. And I think it's important kind of to see this case in the context of how far we've come. The name plaintiff in this Bostock was someone who worked with high-risk kids. So he was a counselor working with children. And we all can remember the day when anyone working with children was determined to be gay. It was presumed that this was a dangerous and illegal, irresponsible situation, and that anyone who would allow a gay person to work with a young person would have to be out of their minds. And, the case didn't even address that issue. That was not an issue there at all. So there was no notion that there could have been some underlying justification that gay people and children don't mix. We've come a really long way.
Yeah.
That is a great way to introduce this case. I'm Nekki Shutt. I'm so honored to be here with my friend Chase and my friend Susan. Susan, y'all, is a hero in the South Carolina community. At the ACLU, she has taken on so many causes, and as a straight lady, she has advocated for the LGBTQ community, with heart and passion and fists for a long time. So as a gay woman, I'm honored to call her friend, and I am really honored to be here today to talk about this case. I do employment law, and I practice with another shero in the community, Melissa Burnett, and Janet Rhodes, and Kathleen McDaniels, and Jack Cahoon, and Sarah Cox, and Grant Burnett Lefevre, and Mandy Mueller. So there are 8 of us. So all those folks, and we do a lot of civil rights work. I am a labor and employment law specialist. So these kinds of cases are the cases that I deal with every day. And this is going to make a huge difference in South Carolinians' lives because Susan already told you a little bit about Mr. Bostock. He worked with kids, and he joined a gay softball league. Now, I've played a little gay kickball. My partner Francie has played a little more gay kickball than I have. She's a little more athletic, but once he joined the gay softball club, they said it was conduct unbecoming and fired him. And also part of the plaintiffs are Donald Zarda, who was the skydiving instructor a lot of us have heard of, who'd had to strap people onto himself and instruct them how to skydive. He got fired when he came out. And then we have Amy Stevens, who was trans, and she came out. She was a funeral director and was transitioned from male to female, and they said she couldn't be a funeral director. So all 3 of those plaintiffs are who we're celebrating today. And this decision is not just about LGB, this is LGBT, because specifically, expressly in this opinion, Justice Gorsuch addressed the rights of the LGBT community and said that Title VII of the Civil Rights Act of 1964, which is our federal law that says that employers with 15 or more employees cannot discriminate, that it expressly includes gay, lesbian, bisexual, and transgender people. And so this opens the door for, we're no longer going to hear married on Sunday, fired on Monday. This protects everybody's right to employment law. If you have a workplace that has 15 or more employees, I do have to add that caveat. So 15 or more employees.
I think that's really good. I mean, that detail right there is important. I want to get sort of more into that piece, but we'll stay in the realm of the positive for a little bit here and not talk about all the exceptions maybe that might be out there. First, I just have to tell you are getting a lot of love on here. Nekki, specifically for you, Francie says hi.
Hi, sweetie pie. I'm actually calling in from a truck stop, y'all, in Tennessee. I left Francie this morning, and I'm headed off to go take care of my mom, so she's going to have to sleep without me tonight.
We know all about truck stops.
I don't even want to know what that means. Well, you've already kind of given a good overview of the cases, and so that's really helpful, I think, for those who maybe weren't following along with this as closely. So those details really help. And you also mentioned Justice Gorsuch, and let's talk about the 6-3 decision and the significance of that. Is there significance in that? Does anyone want to take that?
let Susan go first.
Well, I mean, I think people were surprised. And not only surprised at where his vote landed, but also that he was actually the person who owned this decision. And this, it's just one of those signs that while we've not seen any of these indications in Kavanaugh, there's often been people who've grown into the role. And we would have to say this is a significant indication that Gorsuch is taking his role very seriously and not in a kind of a narrow, dogmatic way.
Mm-hmm. And Susan is a lot more apolitical than I'm going to be. So I'm going to say, you know, when you think of Neil Gorsuch, he was President Trump's first appointee, you know, and you remember President Obama had nominated Merrick Garland and got blocked for the last year of his presidency. So it was a bitter pill for the country to swallow, for Democrats to swallow, that we got Neil Gorsuch instead of Merrick Garland. But now think about it. Here we are 4 years later, and President Trump's first nominee to the Supreme Court, his first appointment, is the man who authored this opinion, and along with them, Chief Justice Roberts, you know, another Republican appointee. So, you know, what I take away from this decision is that it was nonpartisan. So we have a 6-3 decision. The only justices that went against us, they all went to Yale. My friend Justice Strickland pointed this out to me earlier today. So Justice Alito, Justice Kavanaugh, and Justice Thomas all went to Yale. And the folks they were in the minority, they were in the dissent. The folks in the majority were Harvard people. So Harvard won, and you know, the world won today.
That's great. That's great. So let's talk about sort of. I mean, we sort of alluded to maybe some limitations, and I'm learning myself. I'll be honest. You mentioned already the 15 or more being kind of a starting point here. If your employer has less than 15, fewer than 15 employees, this does not apply. What else? Are there other limitations to this decision? If someone's out here thinking, you know, saying, you know, I feel like I'm being discriminated against in my job because I'm trans or because I'm gay, you know, what should they be keeping in mind in this moment?
So, Susan, you want me to take the employment law part?
Sure.
Okay. So nuts and bolts of employment law, when someone comes to our office, for example, and says, I've been discriminated against, when you're covered by Title VII of the Civil Rights Act, that's the best, right? That is the federal law that protects everyone who works for an employer with 15 or more employees. But what that law says, you know, when it was passed, after President Kennedy was shot and Lyndon B. Johnson signed this act, the Congress did not want to open the floodgates on employers to let employers get sued. So they set up, and forgive me if you're an EEOC or South Carolina Human Affairs fan, but they set up a speed bump for employers and for employees. So before they can file a lawsuit, they have to first go to an agency that investigates employment discrimination. So in South Carolina, we have two. So we have the federal agency, which is EEOC. There's only one office in South Carolina. It's in Greenville. And then we have our state agency, South Carolina Human Affairs, affectionately referred to as SHAC, which is down on Senate Street by the State House. And those agencies, you have to go make your charge of discrimination. You have to do it within 300 days of the last discriminatory action. So if there's a pattern, 300 days from the last time it happened, the last incident of discrimination or termination. So what we're looking for is that you're a member of a protected category, that you've been subject to adverse employment action, and you've been damaged as a result. Those are the three things we're looking for. And then before we can sue your employer, you have to go through this process with SHAC or EEOC. The thing that this Bostic decision really changed the landscape on is, up until now, SHAC, so our state agency, had not been investigating sexual orientation discrimination because they did not interpret the word sex in the South Carolina Constitution as including sexual orientation. So, you know, that's been a problem. And if people go to SHAC instead of EEOC, Shaq was trying to wave them up to EEOC, but there are different time frames in both. So there's a 180-day and a 300-day. So this now, gives everybody protection. So it's huge. It's really huge.
Yeah. Susan, do you want to add anything to that?
Well, I think there's still some areas that are kind of not covered by Title VII. There are organizations that are open to the public, and some of them receive a lot of federal money, but are not controlled by Title VII. For instance, some drug treatment facilities, some soup kitchens, institutions like that have not been held to the standards of Title VII. So that I think those are still going to be problems. However, as strange as it seems, especially when we see all this stuff going on, Americans tend to want to be law-abiding citizens. And so if a business, even if it doesn't have 15 employees, hears that they're not supposed to do this, that this is not American anymore, it's likely to have a ripple effect that's bigger than what actually Title VII itself focuses on. And obviously there are other federal pieces of legislation that include similar terms that are not exactly in this case, but there is some indication that this case would also carry over to healthcare, to jury service, to all kinds of things, because the language is basically the same. And so that's why the rule of law becomes so important, is that the implication that therefore the rest of these dominoes have to fall. The big bugaboo is obviously going to be the exemption for religious institutions and how broadly that is going to be interpreted and where that will leave us.
Piggy Park and Maurice Bessinger are still going to discriminate? I'm shocked.
Oh. It's Hobby Lobby. But
Hobby Lobby too. Hobby Lobby. I keep telling Tamika at our office we cannot go to Hobby Lobby, only Michael's, when she needs those new cards. Can I give a tiny bit of a history lesson?
Absolutely.
Are we boring people yet?
No, you're good.
Okay. So one of the things I wanted to just kind of talk about a bit was the fact that in my lifetime, I'm 53, we have kind of had this kind of arc, this circle, and it's a Georgian arc. So it's our neighbors in Georgia. So when you think of this first Supreme Court decision that had to do with LGBT folks, you think of Bowers versus Hardwick, which is about a fellow who worked at a gay bar in Georgia, and he was taking out the trash late one night after the bar closed and holding a beer, and a biased police officer hassled him, gave him a ticket, and the ticket had 2 dates on it, and he had to show up for court, and he missed the date. And so the officer, who had a hard-on, we'll just say, can I say that on Facebook Live?
You just said it.
Sorry. Shit. Oh, I probably shouldn't say that either. Sorry. Anyway.
It's in a truck stop. What can we do?
That's right. I'm in a truck stop. Right. Went to go exercise a bench warrant. So to go arrest the employee, and found him engaging in consensual adult sex in the privacy of his own home. So that's how we got to Bowers versus Hardwick in 1986 in Georgia. At our Supreme Court, and this was, just to put in context, I was 2 years out of Key West High School. I was in the middle of college, and the Supreme Court of the United States said gay people are bad, said gay people do not have the right to private consensual sex in the privacy of our home, which was very, devastating, right? It was crushing to all of us. And now you fast forward 34 years, and we're back to Georgia, to a case, the Bostic case in Georgia, where we have, a nice man working with disadvantaged kids who's playing softball, gay softball, and now we have the Supreme Court of the United States, including Republican and Democratic appointees, saying that gay people have the right not to be fired. Not gay, just gay people. LGBTQ folks have the right to work and not lose their job, not be demoted, not be denied promotions based on their sex. So, and in between that, you have things like Don't Ask, Don't Tell in 1993, And then you have the city of Columbia putting non-discrimination. It's an employee handbook. And then we have Charleston and we have Columbia changing their city ordinances to include non-discrimination. That was 2008 and 2009. And that was before, how many years before? Almost 11 to 12. My math is bad in truck stops. Before the Supreme Court of the United States, our own cities, Charleston and Columbia, prohibited discrimination, first, that long before the Supreme Court of the United States. So, shout out to South Carolina. I mean, we had marriage equality before the Supreme Court of the United States recognized it. In a couple of our cities and counties, we had non-discrimination policies before the Supreme Court of the United States. So South Carolina is not as backwards as people think.
That's good. I mean, thank you for the history and giving us a sense. I think, number one, it's always good to look back and see the progress that was made, all along the way, and to never be, just sort of myopic and just thinking about the present. So I'm just grateful for you to share that sort of the historical perspective of how far we've come. But also the regional perspective. That's wonderful to think about, and sort of how it's all connected here. And you're right, the fact that our municipalities here, local municipalities, have gotten it long before the state and often the federal government.
But that's because people like you, Chase, are changing hearts and minds. That is because organizations like AFFA and South Carolina Equality and the Harriet Hancock Center and Pride and the Gay and Lesbian Business Guild and ACLU, of course, have been changing hearts and minds. That's what allowed all of this progress to happen. I would not have forecasted this. I was surprised today, especially to have a 6-3 decision and such a nonpartisan position. So, I mean, it is many thanks to people coming out that has made this happen, and all of our allies.
Yeah, that's great. Thank you for saying that. And you're right. I mean, the work of so many people who have gone before us and have done this organizing work on the ground, really, when it was even more difficult to do than what we're doing today, for sure. Right. And it was really hard to be out and do this work. Yeah. Think about the, the founders of AFFA in particular, and Linda Kettner right here. Amazing. Just the sacrifice and the work that they have done through the years and continue to do. So we've gotten a few questions here, and I want to make sure that we get questions. If to our people who are watching, please do feel free to ask your questions. I saw one come on here earlier. I'm going to scroll back up through the. Here we go. It's does this have implications? Oh, the coloring is a little weird. I'll work on the how it's the plays on the screen. I'll have to work on that. But does this have implications for LGBTQ fostering and adoption at all?
It should. Now, obviously, the Trump administration has taken itself way out on a limb and taken South Carolina with them. In that we now give federal or state funds to an organization in South Carolina that refuses to use foster parents that don't meet their Christian standards.
Call their name, Susan. Call their name.
Miracle Hill. And the federal government and the state of South Carolina are wasting federal funds fighting in order to keep perfectly competent people from serving the kids in our state who need all the loving people they can get their hands on. But you hear in those cases the old echoes of sort of a moralistic binge. That sort of, we've got to protect our children from these fringe people. So it's I wish I could say that we've completely changed the narrative, but clearly we have not.
Well, and just to bring that back, Susan and I have already spent a couple hours on the phone earlier today because ACLU, South Carolina Equality, Lambda Legal are suing the state and federal government right now because of Miracle Hill, because they are taking public money but discriminating against LGBTQ folks. as foster parents. So, we're challenging that, as we can. We're challenging these things in court one by one. And I should give another shout out to Kevin Hall. I don't know if Kevin Hall's on the phone. He is another lawyer in town at Womble Carlisle, and he just got South Carolina Code Section 593230 overturned, which is the health education law. If Mary Louise Ramsdale's on the call, she will know this because she started an outcry about this several years ago. It was the state law that made teachers not talk about
alternative
lifestyles. That's what it's called. Alternative lifestyles, right? I can't even get it out of my mouth. Yeah. And so you could only talk about straight sex, and even after marriage equality. So Kevin took that case on this year and worked with Attorney General Alan Wilson and Molly Spearman at the Department of Education, and they, without a fight, they gave up on that. So now we have sex education that can talk about gay, straight, lesbian, transgender, all kinds of sex. So,
although there's still some problems with that, with what we've got left, but
there is
chip away.
Okay. Yeah. We're chipping away. That's a good way to say it. We are chipping away.
That is what it's been like, and what it will probably continue to be like, right, in this work. So we're getting a few more questions here. And this has sort of been, a lot of these questions are sort of interrelated, and some of this you've already spoken to, but I want to make sure I put it out there in case there are additional thoughts. Will this set a precedent for healthcare, housing, and education, and thus also sports, which is a very big, topic right now? And I'll sort of piggyback on that as well. I mean, Friday, there was the statement, the ruling, not the ruling, but the announcement of a change in policy from the Trump administration in regards to healthcare for trans folks, and, making it possible for trans folks to be discriminated against. Could this potentially, this new definition, is this setting a precedent, this understanding of the definition of sex and how that could affect other sorts of areas?
I think the optimistic odds are that yes, it will. That rulemaking of the Trump administration was going to get a challenge anyway, but this strengthens the challenge. That's such a mean-spirited and cruel. I want to call attention to the fact that one of the plaintiffs in this case died last month, and she died because she lost her health care coverage because she lost her job. So these things are intimately connected. But hopefully this will clarify the fight in a way that will make it so that these questions will be resolved clearly fairly quickly.
It's not automatic, though. So this, I agree with Susan optimistically. The interpretation of the word sex should have a trickle-down effect. But for this particular statute, what the Supreme Court was interpreting was just Title VII of the Civil Rights Act, which just impacts employment. So it does not impact accommodations. It does not impact education. It does not impact sports. But again, it's certainly going to be persuasive guidance.
Because there are statutes in place that bar sex discrimination in housing, education, right, healthcare, jury service, credit, sports. So hopefully, the dominoes will fall.
Right.
So, and do speaking from someone who isn't a lawyer, is not a legal expert of any sort, do each of those things have to be litigated individually, or is there something that can happen potentially that would, open things up a little more broadly? How does that work?
That it varies a little bit differently from issue to issue because of the way who's actually doing the enforcement. Some of the enforcement is done primarily by agencies as opposed to by the courts. And the agencies can correct course fairly quickly if they have good leadership, which is right now a very big if. But we can see the light at this end of this tunnel. So there might be leadership that it could, in fact, quickly adopt many of these things.
So vote, folks. Everybody
Register
needs to
to
vote. Yeah, that's right. Get out and vote, because what President Obama did was tell his agencies. So those are executive agencies, like the EEOC is an executive agency, and the Department of Education is an executive agency. He told them all to interpret these laws a certain way to include us. And so when the administrations changed, that stuff got undone. So that is why it is so important to vote, because that, leadership can make all the difference. With executive orders, all this stuff can change without us having to go to court and have to fight over these things.
100%. Got to vote. Got to vote. And I mean, along those same lines, you talk about how, this is great, but there's still a lot of work that, is not finished. And, the Equality Act is, I know, top of mind for a lot of folks. I don't want to put either of you on the spot as far as, if you're well versed in that or not, but, could either of you just, even say a little bit about the Equality Act? Or I know I didn't call you to ask you about this, but if you have anything to share, I'd be happy to lean on that.
Well, I think the Equality Act is intended to expand so that it will cover the institutions that I referred to. Any institution that gets any federal money would have to abide by restriction on no sex discrimination. And so that there's, again, it's intended to be even clearer that this should have a ripple effect. It's just, this is not it's not an American way to treat people. It's to make this kind of discrimination. Do you want more specific about the Equality Act?
Not necessarily. No, unless you, Nekki, you've got something to add.
We also have a state equivalent of that that's been working its way through the General Assembly for a number of years. James Smith sponsored it. Todd Rutherford sponsored it. We've had a number of nonpartisan, people co-sign, but it has not made itself out of a drawer and gotten voted on in all these years. So we still need to go forward.
Yeah, we got to get the right people in office to carry those issues forward, right? Well, let's see here. I'm looking to see if we've got any more questions that are coming in. I know I received one earlier today, and I heard someone else talking about it as well. When you're talking about trans folks in the military, and the discrimination there, saying that they can't serve. There's a little bit of a loophole there, some nuance in how they worded it, but could this potentially affect that? Is that one of those things that could potentially be affected? In our understanding, again, knowing it's not maybe direct, obviously, but actually, employees, military, they're employees, right? So how could this play out?
But the military is not covered by Title VII. Military has its own rules. But I do think what you're talking about though is the sort of the affirmation of this is the cultural shift. And if the cultural shift really goes, it goes. And it'll take all kinds of things with it. And this is a significant movement toward a cultural shift that you can't go back on. And so I think the odds are scrutiny of those kinds of distinctions aren't going to hold water.
And historically, the military's been a leader when it comes to integration, from African Americans to women to trans folks. And so, again, we've got executive leadership at the top that's kind of dragging us backwards. So vote. But for civilian folks who support the military, certainly this will have an impact.
Yeah. Well, what else? Is there anything else that you want to make sure that we talked about this evening to make sure we cover all of our bases? I don't want to leave anything out.
Well, I'll use the bully pulpit.
Please.
Because surely we know right now we live in a world that's not a single issue world. And I just want to call attention to some things that seem like wild dreams right now that may be the beginning of a real shift like we've lived through. One is like just the decriminalization of marijuana. That sometimes seems like just a crazy radical idea. And how could you even say those words in South Carolina? But I'm saying the difference that could make to many communities is very, very significant. And saying that and beginning to say it and developing the people who don't run away when you say it, it may just be decades. And decades are pretty quick as change. Same thing true with de-investing in the police, which seems like a radical, crazy sort of thing, and none of us will ever be able to have anything that won't be stolen immediately if we do that. But really, that conversation is about dealing with root causes and not criminalizing everything as a way to solve our problems. And so that conversation may feel a little radical, but again, it might just be a decade or so away if we raise it thoughtfully and with conviction and with perseverance. So just go with those dreams and visions of a better world.
I love that. Thank you for saying that. Nekki, do you have anything you wanted to add to that?
Well, the only thing I would say is that Black Lives Matter, and that I call on the LGBTQ community to embrace our Black brothers and sisters, and let's integrate our community more than we've done in the past. That's a change we can make right away.
Well, and to add to that, I think, at the end of the day, this is, of course, a landmark ruling. This is an incredible thing that's happened, an incredible decision and an amazing victory for the community. But even with protections of employees, we still have particularly Black and brown folks who are victims of violence every day and are targeted, especially LGBTQ, Black and brown folks. And we're talking about Black trans women in particular, who are victims of violence because they live at this intersection of multiple identities that are targets for hate. And, while I'm talking about hate, let's talk about a hate crime law as another law that we need to get passed here in the state of South Carolina to help move our community forward. But, we need to remain vigilant and absolutely Black Lives Matter. And we need to live that out every day and live that. I'm owning that for our organization as well. What does that mean for our conversation, and what voices are we amplifying and centering in this work? As we're just wrapping up here, I think Nekki is frozen up on us, so I'm gonna move her off the screen just for a moment here, and just talk really quickly here and say thank you all, everyone, for joining us tonight. This has been recorded, so we will be putting this onto our YouTube channel, which goes out to our website. If you go onto our website under resources, there's a video library, and you can find us there. And we have a lot of different programs that we've hosted since we began physical social distancing back in March, and so all of that can be found there. This is an amazing day for the LGBTQ community and for our country. And I'm just so grateful that we're able to have Susan and Nekki join us today for this conversation and to learn from their expertise. The Alliance for Full Acceptance is a nonprofit, and we rely on the support of our community members who are willing to help us along. The ACLU as well is doing amazing work and can use your support. And so as you're able, I know this is a tough time for many folks, but as you're able, just encourage you, we'd be grateful for your support and your contributions if you have that ability right now. And it'll help us move forward and continue this work that we're doing. All right, I am going to wrap this up. I don't know if we have Nekki back on or not. I want to see. Nope, she is just a frozen face there. So we're going to. I'll just say thank you again, Susan. Thank you, Nekki, and thank you all for joining us this evening. And please do follow us on Facebook if you don't already, and catch up with and keep up with everything that we're doing as we go forward here. Thank you all so much. Please take care.